Hello and good evening, everyone, and welcome to this evening's webinar on the choice and the duties of guardianship and conservatorship in Missouri. I would like to introduce this evening our presenter, Debra Schuster, who has practiced elder and disability law since 1999. And her practice includes elder law issues as well as disability issues, including her personal experience with her mother and grandfather with dementia, which has given her insight into the stresses that caregivers and families endure when caring for a loved one, which led her to become a certified elder and adult mediator. Ms. Schuster assists families with facilitated conversation about difficult end-of-life issues, when someone should stop driving, moving to assisted living, and other matters. She is passionate about volunteering in the community, and she is past president of the Breakthrough Coalition and is currently involved in the Visiting Nurses Association on their board of directors. Without further ado, I'd like to present Debra Schuster.
Thank you, Anne. Thank you all for attending. We're going to be talking about the choice and duties of guardians and conservators in Missouri. As Anne mentioned, I practice in the area of elder and disability law, but many times people are not really familiar with what that means. And many of you who may be participating may be thinking, what does that have to do with the situation I'm involved in? Well, my definition of elder and disability law includes the breadth of individuals who really are vulnerable populations. So individuals who have mental health issues, individuals who have special needs, certainly elders, individuals who are being financially exploited, and a whole spectrum of others who face unique issues that warrant special laws and special protection. So let's talk about guardians and conservators. First of all, let's review briefly what I'm going to discuss tonight. When is a guardian and or conservator needed? What is required for their appointment? And what is the process? What are the duties of guardians and conservators? And what are successor and standby guardians and conservators? And we'll talk briefly about Social Security representative payee status. So, when is a guardian and conservator needed? If a person does not have durable powers of attorney for healthcare or durable powers of attorney for financial matters that allow them to appoint someone to make those types of decisions for them, if they become unable to, usually as determined by their physician, and they become permanently in need of someone to make those decisions, a guardian and conservator are needed. If a person has never had the mental capacity or the ability to understand and have durable powers of attorney for healthcare and or financial matters created for them, and they turn 18, they are an adult, and therefore parents can no longer make healthcare and financial decisions for them, and a guardian and or conservator would likely be needed. If a person has durable powers of attorney for healthcare and financial matters and is or becomes incapacitated and needs a decision maker, but hasn't either created these documents or has revoked them. Or if a person has these documents, but refuses to follow the instructions of the people that they've appointed. So in effect, their very actions or inaction revokes their powers of attorney. So for example, if someone has created durable powers of attorney for healthcare and is told by their physician that it's no longer safe for them to live at home alone without supervision, and they refuse to leave their home, then essentially, if their individual, the appointee, their healthcare agent that's appointed under their healthcare directive says, Mom, you really need to move to assisted living, and that person consistently refuses to do that, then they've essentially revoked the authority of their agent. And very likely and very often I need to go to court and have the person that they've actually appointed under their documents appointed as their guardian and or conservator. And we'll talk about what this really means. So there are many situations where a guardian or conservator may be needed. So let's talk about exactly what all this legal jargon means. A guardian refers to a person that's appointed by the probate court. And let me pause here. The probate court is a division of every municipal court in every county that deals with very specific issues. Probate courts deal with incapacity, what happens when someone dies and has assets to be distributed, but does not necessarily have a will or beneficiary designations, and other issues pertaining to trusts or challenges to people who've been appointed under estate planning documents, or perhaps even through the guardian or conservatorship process. So the probate court really deals with a very specific, narrowly defined area of law. So a person that's appointed by the probate court as a guardian means that they have been given the authority to usually have the physical custody and authority over a minor individual, someone who's under the age of 18, or someone who's been determined to be incapacitated, and we'll talk about what that means. The powers of a guardian are defined by the probate court. The judge or the commissioner of the probate court that hears the case defines the scope of authority of the guardian. One very helpful way to think of a guardian is you protect someone, you guard their person. So guardians have authority over where someone can live, what they can do, making healthcare decisions for themselves, making psychiatric decisions for themselves, really anything to do with care of the person. That is what a guardian is responsible for and has authority over. Now, the preference under the law is for the least amount of restriction as possible. So there is the concept of limited guardian, and we'll talk about limited conservator also. But a limited guardianship is always preferred if the individual over whom the guardianship is sought can handle that. So it's less restrictive and pertains only to certain areas of decision making. Now, usually a limited guardianship arises only in situations where an individual has mental illness and they are not compliant with medication they've been prescribed or a treatment regimen. So that if they are compliant with medication and a treatment regimen, they have full capacity and can make all personal care decisions for themselves, have insight into their need for medication and treatment. So a limited guardianship is not always appropriate, but it depends very much on a physician's opinion, and we'll talk about that momentarily. So when we talk about guardianship, we're talking about what the law defines as an incapacitated individual. And that is someone who is unable, due to any physical or mental condition, to receive and evaluate information or to communicate decisions regarding their need for food, clothing, shelter, safety, and medical care, to such an extent that they're unable to provide independently for their needs, and to such an extent that physical illness or injury would occur if a guardian was not appointed to help make those decisions for them. So the person over whom a guardian is appointed is referred to as a ward. And the ward is a minor or an incapacitated person for whom a guardian or limited guardian has been appointed. Now, many people say, a ward, isn't that a ward of the state? That is a very different concept. anyone over whom a guardian is appointed is referred to by the law as a ward. A ward of the state is when the public administrator or another entity appointed by the state is responsible for making personal care decisions for that individual. So not everyone who has a guardian appointed for them by any means is a ward of the state. There's no question that the probate court appoints an individual to be guardian for a ward, but very often it's a family member or a friend or another relative. That does not mean they're a ward of the state. So a conservator is almost the flip side of a guardian. A conservator is someone that has been appointed by the probate court. Again, it's either a person or a financial entity to have responsibility over someone's finances and oversee their financial affairs, paying their bills, paying their taxes. And again, and that's over a minor individual or a person with a disability. And the way the law defines disability is not what we would ordinarily assume definition of disability means. Disability in this context refers to someone who's unable to handle their own financial affairs. Now, again, in this context, we see that there's the concept of a limited conservator. And a good way to remember what a conservator is when you are responsible for someone else's money, you want to conserve their funds. So guardian is guarding the person. Conservator is conserving their funds. That's a mnemonic that can help people remember what the distinction of these two roles are. So for a limited conservator, the powers may be limited to the individual over whom a conservator is appointed, to the conservator handling investments or large financial transactions, but for example, enabling the person for whom a conservator is appointed to still allow them to handle their daily bill paying. But again, that is determined by the court. So the person for whom a conservator is appointed is known as the protectee, an individual who needs financial protection and has a limited conservator or a full conservator appointed. So who is involved in a guardian or conservatorship? Now, I just mentioned that the probate court is involved. So in Missouri, there must be a hearing. Some states allow guardian and conservator appointment by consent, but Missouri does not allow that. It doesn't necessarily mean that there's going to be a court battle, but there always has to be a hearing, because the state legislature, in drafting the laws that pertain to the appointment of guardians and conservators, felt that when a guardian or conservator is appointed, the rights of the individual, either the ward over whom a guardian is appointed or the protectee over whom a conservator is appointed, are really losing a great deal of rights. So there should always be a hearing so that they have the opportunity to have their case heard in court. So the petition who's seeking to have a guardian or conservator appointed for someone is known as the petitioner. They're the individual who files a petition, which basically is a request to the court that a guardian and or conservator be appointed for someone. The petitioner does not necessarily have to be the person that is seeking to be appointed. Sometimes there are family members who are very aware of the fact that a guardian and or conservator need to be appointed, but may themselves not be in a position to serve. So I very often have older clients who have adult disabled children and have never petitioned the court to have a guardian or conservator appointed, but they realize as they're aging and may themselves need to move into assisted living or even into a skilled nursing facility, that someone needs to be formally appointed for their adult disabled or incapacitated child, but they themselves can't serve. And so they may seek to have a sibling of the incapacitated or disabled person appointed, or may seek to have the public administrator appointed. And we'll talk about who that is and what role that serves. The respondent is the term used for the person who is alleged in a petition to be incapacitated or disabled. This is someone who's unable, again, to have durable powers of attorney for healthcare and financial matters created or have revoked them due to their incapacity or disability. And finally, there is an individual who is known as a guardian ad litem. That is a lawyer that is appointed by the probate court to represent the person over whom a guardian or conservatorship is being sought. The guardian ad litem is an attorney, and there is a list of attorneys. I have been often that attorney that represents the individual over whom a guardian or conservatorship is being sought. Because again, the legislature felt that the rights of the individual are potentially so significantly being infringed upon and may be taken away that they must have an attorney represent them. So that is the role of the guardian ad litem. It's twofold, really. It's to be the independent eyes and ears of the court to report back to the court what their observations are, for example, whether a guardian and conservator really is needed, and also to represent the individual over whom the guardianship is being sought. So is it always necessary to have both a guardian and conservator? Again, these are two very different roles, and it can be the same individual that serves as both guardian and conservator. That is actually usually the case, that it's one individual that is appointed by the probate court and petitions requesting to be appointed both guardian and conservator for someone. But it doesn't necessarily have to be. I have had many clients who say, I definitely want to be able to help my sibling, for example, make personal care decisions and make sure that they're in the safest, most appropriate living environment, but they don't want to have anything to do with their money. Because sometimes being responsible for someone else's money is fraught with potential conflict. So there are times when people don't want to be the conservator and want to have someone else, potentially a professional CPA or an attorney, or again, the public administrator, which is an office in the probate court that we'll talk about. If there are no assets in the name of the respondent, the individual over whom a guardian and potentially conservatorship is being sought, there is no conservator needed because that person doesn't have any money that needs to be managed. But there should always be a finding of disability. And that is because even if someone does not have assets that at the time of a hearing need to be managed, they may nonetheless come into money at some point in time through either inheritance, through potentially, if there's a lawsuit or a judgment or a court settlement, money that comes to them, or if they have a back award through Social Security. So there are still ways that someone could acquire assets, even if at the time of a hearing, there are no assets in their name. So if assets are in a trust for an individual over whom a petition is filed seeking the appointment of a guardian, and there's a trustee, there is no need for a conservator, because if the court knows that there is a trust and there are no other assets in the name of the individual over whom a guardianship is sought, the court leaves the management of those assets to the trustee that's responsible for the trust. Additionally, if there is only Social Security being received as income and there are no assets, again, in that individual's name, if the guardian applies through the Social Security Administration to be appointed as representative payee, there is no need for a conservatorship, because the court sees that the representative payee role is through the Social Security Administration, and they have separate reporting responsibilities to the Social Security Administration based on the benefit that the individual is receiving, and the court does not feel the need to get involved. That has not always been the case. There have been points in time in the not so distant past that some of the probate court judges did require a conservatorship, even if Social Security was received and there was a representative payee, but that is not the case now. Now, I practice primarily in the city of St. Louis County, Jefferson County, St. Charles County, and some of the other outlying areas, and in Illinois. But jurisdictions may have their own local rules. So even though I'm saying these are generally things that occur in the probate court in terms of not requiring a conservator if someone is appointed representative payee, but if a new judge is appointed to the probate bench, that individual may have a different opinion. So what is required to have a guardian and or conservator appointed? The very first thing, in addition to a petition that explains to the court why an individual needs to have a guardian or conservator appointed, is that a physician must complete what's called interrogatories. Those are specific questions that the court requires be answered by usually the treating physician of the respondent. So the interrogatories usually ask, is there a diagnosis? How long the physician has been treating the individual? Why the physician believes or does not believe that this person needs a guardian and or conservator. And basically from a clinical standpoint, provides the court with clinical documentation as to the clinician's opinion as an expert that the court relies on, instead of the physician necessarily appearing in person and providing testimony in court. Sometimes we will get interrogatories from a treating physician that state that a person does not need a guardian or conservator. And that is usually when the person has sufficient mental capacity to create durable powers of attorney. Sometimes, however, we find a situation where the person has mental capacity to create the documents, but refuses to do that. And unfortunately, that's a catch-22. Sometimes parents will come to me and say that they believe that their child needs a guardian when they turn 18, because you cannot have a guardian appointed. If you are the natural parent, you have not only a legal responsibility, but you also have authority to make decisions for your own child until they turn 18. But I often ask parents that come to me that ask to have a guardian appointed and to start this process, if their adult child has the capacity to create durable powers of attorney. The only downside to durable powers of attorney is that they can be revoked by the individual who's created them. Again, as we spoke a little bit earlier, they can either revoke them by refusing to listen to who they've appointed under those documents, or by really tearing up the document, or refusing to comply with the reasonable request of the people they've appointed. So sometimes we're in this kind of catch-22, but usually if someone does not have the mental capacity to create durable powers of attorney, their physician is willing to complete interrogatories that support the petition. So one way to think of this is that the clinician, the physician, is providing the court with expert testimony that the court will look at. The petition is the anecdotal information provided by family members and other individuals who have first-person knowledge of the behavior and the abilities and the limitations of the individual. So both of those pieces are necessary and have to be filed with the court in order to even start the guardian or conservatorship process. So the second piece is testimony. Testimony by family, friends, or other individuals. I've had social workers, I have had financial advisors, I've had police where there have been issues relating to the police involved, other professionals who've had first-person interactions with the allegedly incapacitated or disabled person. And that again, this creates the narrative or the record for the court upon which it will make its decision whether a guardian or conservator should be appointed. So what happens if we can't obtain physician interrogatories? And unfortunately, there are situations where we can't. If an incapacitated or disabled person's physician refuses to complete or provide interrogatories, a court order can be obtained that requires the physician to complete these interrogatories. We can also subpoena the physician to testify in court, which they absolutely prefer not to do. We can also file a motion requesting an independent psychiatric evaluation. That arises most often when someone does not have a treating physician or has not seen a physician in a significant amount of time, usually at least a year or more. So there's actually no treating physician. Sometimes we have someone who's been in the hospital, but the physician that may have seen the person in the hospital feels that they don't have enough treatment history to really reliably and comfortably render a clinical opinion to the court. And so that is when we have to file a motion for an independent medical evaluation that names a physician that the court requires a potential respondent see and be evaluated by. So again, if we have interrogatories that state that the person does not need a guardian or conservator, then hopefully the person will be able to and will be willing to create durable powers of attorney for healthcare and financial matters. If someone has a guardian or conservator appointed for them, they cannot revoke that authority as they can under durable powers of attorney. So that is one of the positive aspects of a guardian and conservatorship. So what must happen to have a guardian or conservator appointed? Clear and convincing evidence that the respondent is totally or partially incapacitated and disabled must be proven by not only the physician's interrogatories, but also by the testimony that is provided by the individuals who testify in the hearing. So there have been situations where we have had very clear interrogatories completed by a physician where the physician says, yes, this is the person's diagnosis, this is their behavior, and this is their the reason why the physician believes the individual needs a guardian or conservator because they're unable to attend to their personal care needs and or their financial affairs. But we may have family members that don't provide testimony that's consistent with this. And so a lot of times this is a matter of obviously talking to the client before the hearing and educating them in terms of eliciting information in terms of what the person really is capable of doing and what they're not capable of doing. We also need to have an individual that is willing to serve in these capacities and hopefully not be challenged by any other family member in terms of their ability to serve in this capacity. Because sometimes we have dueling family members. So there are two things that must be proven: that an individual is incapacitated or disabled, either in a limited or complete manner, and that we have an individual that is willing to serve, that is not being challenged by anyone else. If either of these two standards are in question, we have what's called a contested matter. And so there may be more of a prolonged hearing, or the hearing itself may be delayed because we need to sort some of this information out, either through obtaining a second physician independent psychiatric evaluation, or we have to have mediation amongst potential family members to hopefully determine who is in the best position to serve on behalf of the respondent to handle their personal care decisions and their financial decisions. And sometimes through mediation, we find that a family member is best suited to be guardian, but that someone else should be conservator. So what is required to file a petition seeking to have a guardian or conservator appointed? So an attorney must be hired to handle the case. You cannot in Missouri do this on your own. So the attorney requests the physician interrogatories from the respondent's physician. Usually we fax and email them and really explain to the physician the level of detail that is required, because sometimes we get one-word answers. Yes, this person needs a guardian or conservator, but with no other detail, and that's not sufficient. So I end up calling the physician and explaining we really need clinical detail to explain to the court why it is your clinical, professional, medical judgment why a guardian or conservator is needed. Again, we need a petition with specific exhibits. So the exhibits that must be attached to the petition identify what, if any, assets are in that individual's name, what income they receive, what family members they have, because all family members over the age of 18 must be served with notice of the hearing, with a copy of the petition, and they have the ability to attend the hearing if they so choose, because they're considered interested people who they themselves, again, could seek to be appointed if they felt that they are best suited to serve in that capacity. And hopefully we will get consent by the family members for the individual who is seeking to be appointed, and also consent of the respondent, because the respondent does have some choice in this matter. If a respondent very vigorously opposes the appointment of the person who is seeking to be appointed, the court will listen to that individual and ask the attorneys if there are alternative family members. And if not, again, it may be a case that falls to the responsibility of the public administrator. If someone needs a conservator because they have assets in their name, the person that's applying to be appointed conservator will need a letter of bondability. A letter of bondability means that this individual has appropriate credit and does not have any record of past financial malfeasance or financial exploitation that would give the court concern that they're not financially or fiscally responsible themselves to handle someone else's finances. Now, unfortunately, with 2008 and with some of the downturns in the economy, people's credit score has affected their ability to be bonded. And the reason the court requires somebody to be bonded is to prevent financial exploitation. So when somebody is seeking to be appointed conservator, the court wants to be sure that there is a company that will replenish the funds of the respondent if the person that's been appointed conservator misappropriates or misuses those funds for any reason that it does not benefit the protectee or the respondent. And we'll talk about what can be spent on that individual a little bit later.
Debra?
So, yes.
We have a comment and a question.
Great.
The reason that you have not received questions so far is that you are explaining things very clearly.
Oh, great.
And then the question is, what is a typical fee for an attorney to handle a guardianship petition?
That's an excellent question, and I wish I had a good answer. It really depends upon what the attorney's fee structure is. Some attorneys charge by the hour. Some attorneys have a flat fee. Most of the time, attorneys who handle anything in court charge an hourly rate because you can never predict how much time is going to be required to handle the court proceeding. So I think usually it is anywhere between $2,000 and $3,000. And then, of course, there are filing fees that are required to file the petition and the fees for the court-appointed attorney, the guardian ad litem. So if someone is seeking to be appointed, they are not required to use their own money to pay for this proceeding. If the respondent has assets, the court will eventually, at the end of the proceeding, allow the petitioner to be paid if they, for example, paid an attorney out of pocket because they don't have access to the funds of the respondent. They will be allowed to be reimbursed for any monies they spent in this proceeding and hiring an attorney and going to court, because they did this really for the benefit of the respondent, to make sure that they had someone that would be able to make appropriate decisions for them. Sometimes the respondent doesn't have any assets, and so it does fall on the petitioner to pay for this out of pocket. And very often that occurs with parents, obviously.
Are there any programs to help with this type of situation?
That's another good question. Unfortunately, Legal Services of Eastern Missouri, that handle a lot of cases for people who do not have the funds to otherwise handle other court or legal matters, does not handle guardian and conservatorships. Sometimes the Alzheimer's Association provides, I believe, grants. They used to be grants in the amount of $500 that could be used towards legal fees. I don't know of any other programs that provide financial assistance for this. What I can tell you is that if someone cannot afford the filing fees in court, which in St. Louis County, I believe they just changed the fee structure. It used to be $636 to actually file the petition to be appointed guardian or conservator before we even got to hearing. But I believe those filing fees have been reduced. You could file what's called an informa pauperis, meaning that the individual who is seeking to file the petition did not have the money to actually pay the filing fees. That doesn't help pay attorney's fees, but that at least would, if the court approved that, would waive the filing fees. And in order to file an informa pauperis, to ask that the court waive filing fees, you had to submit financial information to prove to the court that you actually were not able to do that. And unfortunately, in years past, the court did not often grant that, but they've become much more lenient in doing that. So where's the petition filed? Whoops. The petition is filed in the county where the respondent has his or her official residence. If the individual does not have an official residence, the county in which the respondent is actually living at the time or has property. So, for example, I have had a number of parents, for example, file to be appointed guardian and or conservator over their adult children, but their children are not living at home or in any regular address. They don't have a permanent mailing address, but they are found to be either homeless or in a hospital. And depending upon where the hospital is located, we have filed a petition where that hospital is located. So even if an individual grew up in St. Louis County, once they turn 18, if they leave that home and that is no longer their permanent residence, and they end up in a hospital or a mental health facility in the city, we can file that petition in the city. once you file and once there is a hearing in a particular jurisdiction, St. Louis County, the city of St. Louis, because the city of St. Louis is a county into itself, St. Charles County, the actual guardian and conservatorship remains there unless usually someone moves out of state. And then the matter can be transferred to whatever state, whatever county they move to. That has happened with a number of my clients. But usually the case resides in the county in which it was originally filed, barring someone moving. So the other thing, and this may seem to be obviously self-evident, but it's not always, is we need a respondent. So we need an individual who's physically present in the county in which a petition seeking the appointment of a guardian or conservator is actually filed. So I have had clients, usually again parents, who are seeking to be appointed guardian or conservator for an adult child, but that child cannot be located. So we have the petition ready to go, we have interrogatories ready to go, but if we don't have a respondent, we cannot proceed because the respondent has to be served by the sheriff with a copy of the petition and a copy of the interrogatories. So if we don't have a physical person who has an address, so we've had situations where someone was in a hospital and we told the sheriff that the individual is at, for example, Barnes Hospital. They can be served at Barnes Hospital, but if they're discharged and they're not discharged to an ascertainable address, we have a problem. So what else is required to have a guardian and conservator appointed? I already mentioned that we have to have a hearing in the probate court. If an individual is in a hospital and it is not appropriate to have them released from the hospital, particularly now because hearings are occurring on Zoom or WebEx all the time, the city of St. Louis for years has done hearings where the judge was in the courtroom and the guardian ad litem was in the hospital with the respondent. So it is now possible to have Zoom hearings and to have hearings not only in probate court once things hopefully open up, but even by video. So we also then, once the hearing is conducted, testimony is received by the court. The court issues what's called findings and an order. So the findings are basically a list of the testimony that was provided and heard by the court, and is a document that recites what the judge has found. So that testimony was provided by these individuals, that the court has found that based on that testimony and based on the interrogatories provided, the respondent is indeed incapacitated and or disabled, and that either a full or limited guardian and or full or limited conservator are appointed. So that is it's usually a 2-page list of findings. And then the order is actually letters that appoint the individual who sought to be appointed guardian and conservator. So it's a 1-page form from the court that has a gold seal that says letters of guardian and or conservatorship, depending upon what the individual or individuals have been appointed. So again, if we have one person that has been appointed by the court as guardian and conservator, we will have one set of letters appointing them in both roles. However, if we have 2 people, we will have 2 sets of letters. Letters of guardianship for the person who's been appointed guardian, letters of conservatorship for the person who's been appointed conservator. So who can serve? Any interested person can file a petition seeking to have someone be appointed. So again, the petitioner does not have to themselves ask to be appointed. There have been hospitals that have filed petitions seeking to have a guardian or conservator appointed for an individual that is in their care. I have had nursing homes file a petition seeking to have a guardian or conservator appointed for someone that is in their care. And then I've also had family members petition to have someone else appointed guardian or conservator. And again, particularly individuals who have mental illness. The family really wants to maintain as normalized a relationship as possible. So very often in those situations, they will seek to have someone else other than a family member appointed guardian or conservator. So co-guardians or co-conservators can be appointed usually in very limited circumstances, and that's usually where it is parents seeking to be appointed co-guardians or co-conservators of an adult disabled child. Usually the court will not allow, for example, siblings to be appointed as co-guardians and co-conservators over another sibling. But that, again, depends on the county in which a petition is filed, because judges vary in what they will allow to have happen. So I've referred a lot to the public administrator. Every county has a position that is called the public administrator. That individual is responsible for handling cases where someone does not have someone else to serve as guardian and or conservator, or where someone has died and they don't have someone to serve as personal representative under their last will and testament. So the public administrator is kind of the safety net position in the probate court to serve in the capacity of guardian or conservator for someone who does not have a family member or friend or other suitable person to serve in that capacity. A social service agency, an attorney, or care manager may serve as guardian, and a CPA or attorney or trust company may serve as conservator. So these are some alternative choices who can serve as guardian or conservator. Can an out-of-state person be appointed as guardian or conservator? Yes. The law provides that a person who's not a Missouri resident may become guardian for someone who does live in Missouri, but most courts require that there be a local agent to serve as an emergency contact, and very often that is the attorney that has filed the petition, so that if something happens and the person who's residing out of state cannot be immediately contacted, that there is a local contact. And a statement of what's called frequency of contact, because the court wants to make sure that if an out-of-state person is appointed guardian, particularly because the decisions that a guardian makes are so personal regarding food, clothing, shelter, safety, and medical care, they want to make sure that that person who lives out of state has enough contact with the person that they're being appointed to be responsible over. And so you may wonder what frequency is sufficient. And usually the probate court says that if someone who lives out of state has contact, physical in-person contact with the ward at least 3 to 4 times a year, that is sufficient. Now, certainly by telephone, by Zoom, by video conference, the court requires contact be much more frequent in that manner. But when we're talking about in-person frequency of contact, the court usually accepts an affidavit that the person will come and see the person at least 3 to 4 times a year. A person who lives out of the country cannot be appointed guardian. And courts do not always appoint out-of-state residents as conservators, which is changing to some degree, because now with all of the technology we have, it's so easy to handle financial matters remotely, even if you live across, around the world. But traditionally that has been the case.
Debra?
Yes.
We have a question that falls along those lines. So
Sure.
once appointed guardian, if the respondent and the guardian both move out of state together, is the appointment still in effect?
Yes. So that is when I was referring to transfer of a guardianship. I've had many situations where both the guardian, for example, the guardian moves out of state and wants the ward to move with them. So let me step back for a second. Once the hearing is held, the person over whom a guardian or conservatorship is being sought is no longer referred to as the respondent, because the respondent is the person who is allegedly incapacitated and disabled and is responding to the petition. So once the hearing is held, they are then called the ward, if they have a guardian appointed, or the protectee when they have a conservator appointed. So when both move out of state, the case would be transferred to the state and the county to which the guardian and the ward move. So I do see two other questions. Is it costly to transfer the guardianship, conservatorship to another person or agency? Again, when you talk about to another agency, once the hearing is held, usually if we're transferring the guardianship to another individual or, for example, a social service agency, all that needs to be filed is a request that that individual or agency be appointed. There doesn't need to be a full hearing. There usually just needs to be a meeting with the judge of that individual or agency. So it's usually not that costly. It's usually just the attorney's time.
So does anything have to be filed in the new state?
Yes, yes. So there has to be the documentation from Missouri, the findings and the order have to be filed in the new state. There has to be an attorney in the new state willing to file guardian and conservatorship petition in that state and file the judgment from Missouri in the new state to have the guardian conservatorship transferred. So you have to have a transferring state and an accepting state, and attorneys in both. So we talked about the guardian ad litem, again, who is the independent eyes and ears. They really serve that dual role, serving as the independent eyes and ears of the court and the attorney who represents the respondent. The guardian ad litem is required to visit the respondent prior to the hearing. Unfortunately, not all guardians ad litem visit the respondent before the day of the hearing. When I'm the guardian ad litem, I make an appointment with the person who is seeking to be appointed as guardian and or conservator, try to meet them at the home if the individual is living in the home, or if the respondent is in a hospital, I would meet the respondent in the hospital or wherever they're located, and then meet the individual or individuals who are petitioning to be appointed guardian and conservator wherever they are. Because again, my role when I'm guardian ad litem is to ascertain for the court whether there is a need for a guardian and conservator, and if the people who are petitioning to be appointed, I feel are appropriate. If the respondent wants to hire their own attorney, instead of just the guardian ad litem that is appointed by the court, there must be another hearing before the guardianship hearing. That hearing is called a link hearing, and that enables the court to determine on its own if the respondent has the capacity to hire their own attorney. In that case, if there is a respondent that says, I don't want a court-appointed attorney, I want to hire my own attorney, the court has the respondent come to court, and the court is the only one that asks questions of the respondent to determine for itself if they feel that the respondent has sufficient mental capacity to enter into a contract to hire their own attorney. Even if the court does believe that the respondent has the mental capacity to hire their own attorney, they very often still keep the guardian ad litem in the case just to make sure the court still has that independent eyes and ears kind of over the whole situation. The law provides for paying reasonable attorney's fees to the guardian ad litem, the attorney that's serving that in that capacity. That guardian ad litem's fees are charged to the estate of the respondent, or if the respondent has no income or assets other than SSI, the county will pay the guardian ad litem's fees. So what are some stumbling blocks? We referred to them a little bit ago. When a petition and interrogatories are filed, the respondent must be served by the sheriff with a copy of the petition, the physician interrogatories, and a list of their rights, which I'll talk about in a moment. And if the respondent will not answer the door when the sheriff arrives, or the respondent is not present when the sheriff arrives to serve the notice, or if the address for the respondent is not accurate, that can be a stumbling block, which can delay the hearing. Because what happens is when we file a petition and when we file the interrogatories with the court usually within about 3 to 4 days, if I'm the filing attorney, calls me and says, we have these dates available. And I call my client and ask, are these dates acceptable to you to be able to come to the hearing? So the court then prints up a notice of hearing that is served first upon the respondent and again served by the sheriff. Unfortunately, again, when we're dealing with cases of individuals who have reduced mental capacity, having a sheriff come to the door in full uniform can sometimes be very intimidating, and they will refuse to answer the door. Unfortunately, we've not been able to convince the sheriff's department to send plainclothes individuals to serve the petitions usually, nor can we necessarily always coordinate with family members to be at someone's house when the sheriff serves the petition to hopefully reduce the anxiety of being served a petition. So those are some of the stumbling blocks that can occur. If the sheriff is not able to serve the petition when they first try, and the sheriffs have hundreds of petitions that they're serving, so they will try 3 or 4 times to go back to the address that we've given them, and if they still cannot serve the petition, they have to serve the petition physically upon the individual. They have to have the person open the door and accept it. Then the attorney has to file another request to the court to have the sheriff file the petition. So these are all things that can cause delays in the hearing. If the sheriff is successful, then the guardian ad litem is required to meet with the respondent. And I have been in the position of standing on someone's front step, yelling through a closed door to an individual who refuses to open the door. But the court has said that as long as I have made contact, even if the person refuses to talk to me, I am informing them of their rights, who I am, and I know that they have received notice from the sheriff that identifies me, has all my contact information, and notifies them of their rights, then the court says that that is sufficient to continue with the hearing. So again, more stumbling blocks. If there is a dispute over whether the respondent is incapacitated and disabled, an independent physician evaluation will be required. And that dispute can occur not only by the respondent, by other family members. I have had other family members say, I don't feel that so-and-so over whom a petition has been filed is incapacitated. And so we have to ask the court to require or file an order for an independent psychiatric evaluation. Again, if the physician does not agree that a guardian or conservator is needed, that's certainly a stumbling block. If the respondent has moved out of state or can't be located, and again, if there's disagreement over who should serve as guardian or conservator, these don't necessarily prevent the appointment of a guardian or conservator, but they certainly delay the process. So What happens if there's disagreement? As I mentioned before, if there's a dispute, usually between family members, regarding whether the respondent is incapacitated or disabled, or over who is the most appropriate person to serve, the court will consider the case contested and will postpone the hearing and schedule it on the contested docket, meaning they leave a much longer period of time. It can be a half a day, it can be a couple of days for the hearing to occur, and will usually appoint the public administrator if they have warring family members, because they don't want to put the respondent in a position where there's going to be constant family strife. Now, if the respondent does not agree or does not want a guardian or conservator, the court will not usually reschedule the hearing, but the guardian ad litem will encourage the respondent to testify, to express his or her own opinion as to their disagreement over the appointment of a guardian or conservator for them. Because frankly, it's not unusual in all cases for the respondent to disagree that they need a guardian or conservator. You know, in the best of all possible worlds, there won't be disagreements, but it's not always the case. So I've mentioned that the respondent has rights by law. They have the right to be represented by an attorney. And again, the court appoints an attorney to represent them. They have the right to be present at the hearing, but they also have the right to not be present at the hearing. They can refuse to be at the hearing. They have the right to present evidence on their own behalf. For example, if they disagree with either the person who's seeking to be appointed, or they disagree that they need a guardian or conservator at all. They have the right to cross-examine witnesses, to present their own witnesses. They have the right to remain silent. They have the right to request that the hearing be open or closed to the public. They have the right to request an independent medical or psychological examination with the fees, again, paid by the county if the respondent cannot pay for the examination. And finally, they have the right to request a jury trial. Now, in 29 years of doing this, I have only had 2 clients request a jury trial. And I have never had it actually go to a jury, because the guardian ad litem has usually been able to convince the respondent that it is usually not in their best interest to have a jury trial. Because usually the judge really understands these situations to a much more in-depth degree than individuals sitting on a jury. And not only that, it is much more expensive and time consuming if the individual requests a jury trial. So on the day of the hearing, most hearings are not contested, so the hearing itself is not adversarial and is actually very short. The attorneys involved, the judge, everyone that is involved in guardian and conservatorship hearings is usually very compassionate and very understanding. So they want what is best for the respondent. So this is not an adversarial proceeding unless family members usually make it so. The interrogatories are presented to the judge as evidence, and the physician is not required to come to the hearing. Now, I have a very unusual case right now where we are going to require, and the physician has actually offered to come to court, because in this situation, the boyfriend of a woman who was incapacitated took her to an attorney, an unethical attorney, to create estate planning documents that, instead of naming her daughters, named him as her decision maker. And she was already incapacitated. So her physician of 20 years has agreed to come to court to testify to the court that the documents that she signed should be invalidated, because this physician has treated this woman for 20 years and said there is no way that she understood what she was signing. But that is very unusual. So on the day of the hearing, if the attorney representing the petitioner and the guardian ad litem do not agree with the physician's opinion, as stated in the interrogatories, the physician may need to come to the court and testify, or the guardian ad litem will request another physician evaluation. That has happened on a couple of occasions where the physician is required to testify in court so they can be cross-examined by both the guardian ad litem, the attorney representing the petitioner, and frankly, the court. So on the day of the hearing, witnesses will testify at the hearing. And if the court agrees with the testimony and the physician interrogatories, the court will usually make a finding and enter an order at the hearing. If there is the possibility of the respondent becoming very upset or family members becoming very upset, the judge will say, I will take this matter under advisement, meaning that they will not announce their decision in court and instead will issue their decision in writing at some later time that is emailed to both of the attorneys that are involved. After the hearing, the appointed individual will meet with the court staff attorney who explains the duties of guardian and conservator, which hopefully have been explained to them by their own attorney. So again, I referred earlier to something called the least restrictive doctrine. This is a very, very important standard in the law that requires the ward or protectee's liberties should be limited to the minimum extent necessary to enable him or her to be as independent as possible while ensuring his or her safety and that their needs are met. And this applies to where they live, to their social interactive issues, and the handling of their finances. So before I get to costs, when someone is petitioning to be appointed guardian, the court wants to know whether they want to enable the respondent to maintain the right to vote, the right to drive, and the right to marry. And depending upon the ability of the individual, some or all of those rights can be retained. The right to drive is always going to be contingent upon the individual passing the written and driving test that's administered by the state of Missouri. And the right to vote is almost always preserved unless the person has never had an interest in voting or would not comprehend what the voting process means. The right to marry can be somewhat dicey, particularly if it's parents that are petitioning to be appointed. They have varying opinions that, usually they want eventually their child to be able to marry, but maybe not at the time of the hearing. And that can always be changed. So all of this can be changed. So if someone particularly, again, and I don't mean to keep using this example, but this is most often when it occurs, there is a process to reverse a guardian in conservatorship. It's called restoration. So in the same way that we obtain physician interrogatories when we're first petitioning the court to have a guardian and or conservator appointed, if the individual, the ward or protectee, is able to regain the ability to understand and evaluate information and make appropriate and safe decisions regarding their personal care needs and their finances, they can seek to have the physician complete interrogatories to have them restored, meaning to have all their rights restored and have the guardian and conservatorship removed. And that is a very happy day. So, costs. We talked a fair amount about this. The petitioner or someone else bears the costs for hiring the attorney, filing the petition, and the costs regarding representing the petitioner. If the guardianship matter is contested, costs may increase to heaven knows what. I have actually had contested guardianships where people have insisted on taking depositions and a full-blown litigation case. Costs are usually charged to the estate of the respondent unless the protectee only receives SSI. and has no income or only a home. And again, indigent petitioners may file a motion in form of papyrus asking the court to waive the filing fees and costs, meaning filing fees and the sheriff's fees. The burden of proof is on the petitioner. So if the petitioner does not have interrogatories that are strong enough that make the case clinically that the person is incapacitated or disabled, or does not provide testimony that makes the case by clear and convincing evidence for the court, then the judge will not appoint a guardian and conservator. Now, that has never happened when I've been involved, but sometimes the court will ask someone who's on the stand, usually a family member, some questions to elicit more information to enable the court to make that determination. The petitioner calls the witnesses first. The guardian ad litem can cross-examine the petitioner and the witnesses, and then it's the respondent's turn. The respondent, again, can choose to come to the hearing, can choose to appear themselves, and can call witnesses, but very often the respondent usually does not have witnesses. After the petitioner presents his or her testimony and evidence, the guardian ad litem gives his report based on their meeting with the respondent. The respondent can make a statement if they wish, and the court again will take that all into consideration and put that into evidence. And the judge then makes his or her ruling, and either at the hearing or at some time after. So the effect on the warden protectee are that their rights are relinquished, their ability to consent or refuse medical care are given up. The right to vote, unless it's preserved, the right to marry, again, unless it's preserved, the right to make and enter into enforceable contracts. I have had people petition the court because they have relatives who are being financially exploited. Even if they don't have any assets in their name, they're seeking the protection that a conservatorship can provide because they cannot enter into contracts. So if someone sends them all sorts of information about credit cards, or if they're seeking to send them money to deposit in their bank account, the conservatorship will protect them, because once a conservator is appointed, depending upon the scope of authority that the court appoints, the protectee cannot maintain their own bank account. The conservator has to open a conservatorship account. And again, the right to obtain a driver's license and the right to drive.
So what is the process for naming a new guardian conservator in the event of death or incapacitation of the current one? Do they need to petition the court?
Yes. A petition has to be filed. There does not need to be another full hearing, but there does need to be a petition, the death certificate of the individual who died, or a letter of incapacity from the physician of the then currently serving guardian or conservator is filed with the court, and a petition seeking the appointment of another individual has to be filed with the court. So how does the guardian and conservator prove his or her authority? Again, the court issues letters of guardian or conservatorship, and they identify the scope of authority that is granted, either limited or full authority. And it is the responsibility of the attorney, when they are first sent those letters, before they mail them out to their client, to make sure that the letters of guardian or conservatorship reflect the actual findings of the court. Because I've had to call the court and say, you misspelled this person's name, or you did not enter the order that you actually made findings about. So they issue one gold sealed document, and then I usually recommend that certified letters be obtained so that the guardian and conservator has multiple copies in the event that they're required by usually financial institutions to give an actual sealed copy from the court. So the letters are going to be given to all healthcare providers, evidencing the guardian's authority to make medical decisions. And the conservator will give copies of the letters to all financial institutions to show that they now have responsibility over that individual's financial affairs.
So how do you get certified copies?
You contact the court, and you don't need a lawyer to do that. You contact the probate court, and the clerk of the court will order the letters, and I believe they're $2.50 a copy. And it has the official court seal on it. Guardian duties. The guardian must assure that the ward lives in the best and least restrictive environment commensurate with the needs of the ward. Assure that the ward receives needed medical care and other services. Promote and protect the care, comfort, safety, health, and welfare of the ward, and provide required consents so they are authorized and responsible for consenting to treatment and, where appropriate, refusing treatment. And they have to complete an annual report that the court sends to them every year. And it's a very straightforward 2-page report asking where they live, where the ward lives, if the individual still needs a guardian, what their current treatment plan is, and how often the guardian has seen the ward. And that usually is sent to the guardian about a month before the anniversary date of their appointment.
What can you do if a ward enters into a contract without the guardian's approval?
If a ward enters into a contract and there's no conservator and there's no finding of disability, there is not a lot that the guardian can do. Because again, guardianship is over the person. Conservatorship is over financial transactions, including the right to contract and to enter into contracts. So what may need to happen is the guardian may need to petition the court to have a conservator appointed and may seek to have the contract voided by the court. I know that may not be an acceptable answer, but that's, I mean, very often I have had to write letters to this is an interesting story. I had a client years ago that had a guardian appointed and a conservator appointed, and she lost the right to drive. Nonetheless, she took a cab to Enterprise, gave them an old credit card that somehow had not been shut down. She bought a car and told them that she could not drive. So she actually had the person at Enterprise drive her to her house in her new car, and we had to petition the court to enter an order voiding the contract. So the conservator duties. They must account for all of the protectee's income and expenditures made for the protectee. As soon as a conservator is appointed, there are 2 things that have to be filed. An inventory of all of their assets and income, and that is on a form that the court requires be completed by an attorney, and a monthly support order or a budget that the conservator puts together asking the court for pre-approval to pay regularly occurring expenses on behalf of the protectee. Because otherwise, the conservator would have to come back to the court every month and constantly be asking for approval to write checks or pay bills that are regularly occurring. So we file simultaneously an inventory and a request for a monthly support order. And the conservator only has the authority to pay the expenses that are approved in that monthly support order unless there is an expense that falls outside of that order, such as, unusual dental work or some other expenditure that needs to be made that we have to separately file a petition for that the court would then hopefully approve. If the conservator goes off and just pays an expense without court pre-approval, they run the risk of being held personally financially responsible for that expenditure. Finally, at the end of the anniversary date of appointment, they must file an annual settlement. And this is the most laborious and tedious thing that the conservator has to do. They have to file bank statements showing every account that is in the conservator's name, because any accounts that were in the protectee or the respondent's name have to be converted to a conservator account. And they have to file evidence of all bills and all evidence of payment made. So essentially, when I am helping an individual manage a conservatorship, I have them send to me on a monthly basis the bank statements, bills paid, and the checks or evidence of payment, so that we build the annual settlement month by month, so that by the time the anniversary date arrives, we have it all in an Excel spreadsheet with every single document that the court requires. And unfortunately, you have to have an attorney file the petitions and the annual settlement and all of the documentation required under a conservatorship. If someone has a guardian appointed and they come into money, either through an inheritance or a lawsuit, settlement or judgment, or a back award, they can actually have an attorney petition the court to have a special needs trust created for them. Because again, if there is a trustee, there's no need for a conservatorship and this ongoing cost in filings that the court requires. So very often I will file with the court a request that the court order the establishment of a special needs trust for an individual who is disabled and needs someone else to handle their finances, thereby taking that money out of the jurisdiction of the court and instead placing it into a special needs trust with a special needs trustee. So there is an ability to remove and appoint successors, and the ability to appoint a standby guardian can be nominated by a custodial parent for a minor or a disabled child in a writing that is witnessed and notarized in a will or some other similar type of writing. And the standby guardian can act if the custodial parent is incapacitated or dies. And it may be the non-custodial parent. They have to notify the court within 10 days of beginning to serve and may be appointed by the court without a hearing, which is very unusual. But within 60 days, the standby guardian must file a petition seeking to be appointed. So this is different than a successor guardian. This is where usually there is a custodial parent for a minor child who is, and the custodial parent is becoming incapacitated. So Social Security, again, it's usually a conservatorship is not needed if someone is just receiving Social Security benefits. This talks about seeking appointment as representative payee. Again, the petitioner may apply to become a representative payee to receive Social Security, disability, or SSI benefits on the protectee's behalf. And they are individually responsible to the federal government, the Social Security Administration, for reporting how that money is used, depending upon the type of benefit that person receives. So the main duties of the payee are to use the benefits to pay for the current and foreseeable future needs of the beneficiary and to save any benefits not needed to meet current needs. This is how to become a representative payee. There has to be an interview, an application has to be submitted, and there has to be usually a face-to-face interview. Once a representative payee is appointed, they have to set up a checking account for the beneficiary that is usually called a representative payee account for the benefit of, for example, Debra Schuster. And again, the funds that are received have to be used on behalf of the individual for whom the person is appointed representative payee. So that pretty much covers the waterfront. Well, thank you for this opportunity.
Thank you, Debra. We're always glad to have you.
Wonderful. Thanks so much.
Bye,
Have a good
everyone.
day, everyone. Bye-bye.